I'm John Landy, a retired law professor at the University of Missouri Law School. This video is designed to help mediators understand and improve your mediation practices. You can use these ideas in every type of case, from small claims disputes between neighbors to multi-million-dollar business cases and everything in between. You can use them at every stage of practice, from novice to mid-career to senior mediator. This video also should be helpful for students and trainees first learning about mediation, though it is particularly directed to people who have mediated regularly in the past. Let me tell you a little bit about my background and how I developed the ideas in this video. I graduated from law school in 1980, and I took mediation training starting in 1982. I practiced law and mediation in California in the mid-1980s, and then I got a PhD in sociology studying dispute resolution. I directed a child protection mediation clinic in the late 1990s, and I have been at the University of Missouri since 2000, teaching and writing about mediation and other dispute resolution processes. Like most people in our field, I use traditional mediation theories like facilitative and evaluative mediation. But the more I studied them, the less comfortable I became with them. They are very incomplete, as they don't deal with many important aspects of mediation. They also are misleading about the effects of various mediation techniques. So this led me to develop what I call the real practice systems theory to help mediators develop more realistic understandings of how mediation actually works. This theory can be applied to other dispute resolution processes as well, but this video focuses only on mediation. So let's get started. I'm going to start by giving you an overview of the real practice system theory, and then I will describe 3 hypothetical mediators to illustrate the theory. Finally, I will suggest how you can improve your mediation system. Whether you know it or not, if you mediate regularly, you have a mediation practice system, which I will call a mediation system for short. This video describes mediation systems generally. As you watch, think about your own system. So what's a mediation system? Many people think of mediation as involving only activities during mediation sessions. That is, when everyone gets together at the same time to discuss the issues, though they may be in separate caucuses. Preparation for mediation sessions is a very important part of the mediation process. Mediation sessions are likely to produce a much better process and outcome if everyone is well prepared from the beginning of the session. Preparation can be an extremely important part of mediator systems, though some mediators can't arrange for preparation before their mediation sessions. Mediation systems also can include actions after the sessions. Mediators may need to follow up with the parties regardless of whether they reach agreement or not. Mediators also can use this time after sessions to learn from their experiences and improve their techniques in future cases. Mediators do some things unconsciously, often as part of their regular routines, such as providing information before mediation sessions or at the beginning of sessions. And they certainly do some things consciously, for example, when parties seem stuck. Mediators' personal experiences and ideas make a big difference in their actions. For example, their experiences with their family, schooling, communities, and training all can affect how mediators think and act in their cases. These experiences contribute to their values and goals, such as treating others with respect, helping parties make their own decisions, and avoiding court proceedings, among many others. Of course, mediators handle a wide variety of cases, and they act differently based on the type of case. For example, mediators use different techniques in small claims, family, personal injury, and large business cases. And they develop categories for cases and parties. For example, they may consider some cases more or less complex. They may consider some parties to be sophisticated and reasonable, and other parties not so much. As a result of factors like these, mediators develop their own unique systems for mediation, including both routine procedures and strategies for dealing with the recurring challenges. This video and related resources are intended to help you better understand and improve your own unique mediation system. To illustrate real practice systems theory, I'm going to describe the systems of three hypothetical mediators. Andy is a high school teacher trained as a volunteer mediator by his local community mediation center. He learned about the center when some of his students had good experiences resolving their conflicts. He generally approaches things in his life with a mediation mindset, and he likes helping people solve their problems. Bahar is a family lawyer who has practiced family law for 10 years and has been mediating for the past 5 years. She particularly wants to prevent emotional harm to children of divorce. She's found that mediation has helped her clients manage their divorces as constructively as possible. She mediates some cases, and she represents clients in other cases. Carmen is a retired judge who handles large multi-party civil cases. When she was on the bench, she was frustrated trying cases that she felt should have been settled. The attorneys and parties often had unrealistic expectations about the likely court outcome, and they wasted a lot of time and money on unnecessary litigation. So she enjoyed conducting settlement conferences to settle cases as efficiently as possible. Now, as a retired judge, she has more freedom as a private mediator, and the pay is better. Obviously, these aren't the only systems for community, family, or civil mediators, and that's exactly the point. In each of these contexts, individual mediators use their own system. Each mediator system is a reflection of an infinite possible combination of variables. So let me tell you about Andy's system. Andy mediates whatever cases the mediation center asks him to mediate. His cases involve some people in small claims court and others where there is no legal issue. The cases may include disputes between neighbors or landlords and tenants, for example. Very few of the parties are represented by attorneys. Many of Andy's cases involve parties who have had a relationship and then something caused a break in their relationship. They often primarily want respect and vindication. Often, monetary issues are just proxies for their emotional and relationship concerns. Andy's goal usually is to help people communicate and maintain their relationships if possible. Community Mediation Center routinely gives parties basic information about mediation, but it does not have substantive conversations with them before mediation sessions. So Andy starts his mediations by giving a detailed description of the process, and then he asks the parties to tell him about their dispute. The biggest problem he experiences is when parties are so angry that they yell insults at each other, leading to a downward spiral of communication. He was trained to handle bitter disputes by expressing respect for all parties and actively listening to their perspectives, often in caucus. Bahar mediates only divorce and parenting cases. She serves a middle-class clientele, all of whom have separate attorneys, though the attorneys usually don't attend the mediation sessions. Of course, her clients all have had a relationship with each other, though the length of their relationships and the level of their hostility or cooperation varies quite a bit. The parties have a wide range of goals, including maintaining their relationship with their kids, providing financial security, getting revenge for their spouse's affairs, and moving on with their lives, among many others. Bahar's goal generally is to promote healthy family reorganization. She's concerned about the risks of mediating when there has been domestic violence. So before she holds any mediation sessions, she routinely has a separate phone call with each party to screen for domestic violence. She has the hardest time with cases in which the husband has coercively dominated his wife. When she talks with each party before a joint session, she assesses if there's been a history of abuse as well as the party's decision-making abilities. When she identifies problematic situations, she discusses whether mediation is the most appropriate process. One option is to mediate completely in separate sessions. She also considers other safeguards and whether to engage additional professionals in the process. Now, Carmen mediates a variety of large civil cases, specializing in cases in tech industries. She mediates cases involving large corporations, each of which sends a team that may include outside counsel, inside counsel, executives, and/or experts. Some of her cases involve business relationships gone bad, and others involve torts where the parties haven't had prior relationships. Carmen's clients generally want to receive as much money as possible or pay as little money as possible. The attorneys often want to show that they would win at trial. Carmen's goal is to help parties resolve their disputes efficiently. Before mediation sessions, she has separate phone calls with the attorneys, and she requires them to provide her with a memo summarizing the case. She has a hard time when parties or attorneys have very unrealistic expectations about the likely court outcome and are unwilling to listen to reason. When this happens, she uses decision analysis to help people realistically understand the risks and possible court outcomes. She also helps parties identify the intangible costs of continuing to litigate, such as damage to their relationships and reputations. She includes these factors in the decision analysis. So, having considered the systems of these three mediators, think about your own mediation system. What kind of cases do you mediate? How would you generally describe the participants in your cases? What usually is the history of the cases? What are the typical goals of the participants? What are your goals? What do you do to prepare yourself and the participants for mediation sessions? What are common challenging situations in your cases? And how do you handle these situations? I'm going to pause for a few moments so that you can think about your own system. If you're a student or trainee, think about the system that you would like to have. We're familiar with the concept of people's careers, that is, the series of events in their work history. We can also think of the careers of mediators' systems, which parallel mediators' careers of jobs and cases and so on. The careers of mediation systems involve progressions of training, skills, complexity, and size of cases. When people start mediating, they have simple ideas based on their training and/or their intuition. Over time, they get more experience and they refine their ideas and their skills. They may specialize in some types of cases, and they may handle bigger and more complex cases. As a result, they may refine their procedures before, during, and after mediation sessions. So let's look at the careers of the systems of our three mediators. Even though Andy doesn't mediate professionally, his system has a career. At the beginning of the career of his mediation system, he mostly used scripts that he learned in his basic training. In his first few mediations, he mediated as if he was following all the steps in a cookbook recipe. Over time, he learned to improvise based on his observations about different kinds of parties, cases, and the effects of his techniques. Increasingly, he decided what to do based on the mindsets and behaviors of the parties in each case. He regularly co-mediated with other mediators, and he borrowed some of their techniques, and he also identified some things that he didn't want to do in his cases. He also participated in the center's continuing education programs, which led to further improvement of his approach. Eventually, he became a trainer for the center. Teaching mediation led him to reflect on his experiences and make subtle changes in his approach. Bahar's mediation system began when she was in law school. Mediation was briefly mentioned, and she got only a hazy idea about how it works. When she was in practice, she got an on-the-job education. Some of her clients told her about their mediation experiences, and she talked with mediators outside mediation sessions. When she decided to start mediating, she attended a training and read lots of books and articles. Over time, she developed a sophisticated understanding of mediation theory and practice. She joined an educational practice group consisting of traditional and collaborative lawyers, mediators, and mental health professionals who work with families. In their regular meetings, they discuss their hard cases and possible techniques for handling them. There was no instruction in ADR in Carmen's law school when she was a law student. And when she was in legal practice, very few of her cases were mediated. When she was on the bench, she didn't know much about mediation, except that it was helpful to send difficult cases to mediation and avoid sticky trials. Over time, she conducted settlement conferences and really enjoyed doing them. She didn't have any training in settlement techniques. She just relied on her intuition about what might be effective in getting parties to settle. After she retired from the bench, she joined a panel of neutrals and she took advantage of their training programs. She now regularly attends programs where mediators exchange stories and tips about their mediation techniques. So let's think about the career of your mediation system. Did you attend law school or another university program and learn about mediation? If you took a mediation training, what were you taught about the right and wrong ways to mediate? How has your mediation system changed over time? And why did you make any changes in your system? Again, I'm going to pause for a few moments so that you can think about the career of your own mediation system. The descriptions of Andy, Bahar, and Carmen's mediation systems were simplified for illustration. In the real world, mediator systems are much more complex and varied. All mediators have their own unique systems based on the factors I mentioned at the beginning. Some mediators' techniques are highly conscious and intentional, effectively using procedures that help parties work together and reach agreement. Some mediators' techniques are much more routine. They don't focus on the specific issues and parties, and instead they operate as if on autopilot, treating cases as if they're all pretty much the same. To learn about some real mediation systems, read the short article, 10 Real Mediation Systems. 10 experienced mediators described how they mediate and why they designed their systems as they did. On the Indisputably blog, I collected resources to help you improve your mediation system. They are in a post entitled, Helping You Do the Best Mediation You Can. You can go to indisputably.org and search for the post. Use the magnifying glass icon in the upper right part of the screen to do the search. That blog post links to several articles you can read. I especially recommend the 10 Real Mediation Systems article to give you a more realistic understanding of mediator systems. The post also links to an exercise to help you identify factors affecting your unique system. It also links to a document with a detailed menu of checklists that includes a wide range of mediation procedures. You can use these checklists to design your own system. And you can select procedures that you might use and delete ones that you wouldn't use. You also can participate in an educational practice group to continue learning about and improving your own mediation system. I hope you found this video helpful for your work in mediation.